Okay, so in this lecture we are going to study about fundamental rights. Fundamental rights that contains from Article 12 to 35, and it is in Part 3 of the Constitution. There are some case laws that are also attached to it. So, fundamental rights that is in Part 3, Article 12 to 35, and in USA we call it Bills of Rights. So we call it Magna Carta of the Constitution. It is guaranteed. It upholds the equality and dignity of individual, larger public interest, unity of India, some of the citizens and some for all persons, and it is not absolute but qualified. Restriction by state justiciable hai. It is non-sacrosanct and it can be amended by the Constitution Amendment Act. It is suspended. It would be suspended in national emergency except Article 20 and 21 that will remain unsuspended. Members of armed force that can be restricted by the Parliament under Article 33, and it can be restricted while martial law enforced in the area under Article 34. So there are 6 articles that is in 6 rights basically in Article 19 that is suspended only when the emergency on the ground of war or external aggression, not armed rebellion, that is internal emergency. So that is mostly directly enforceable, while some can be enforced by law made by the Parliament. So if we have basically classified into 6 parts, and part 1 like right to equality. Here Article 14 to 18 deal with right to freedom, that contains from Article 19 to 22 right against exploitation, that is 23 and 24. Right to freedom of religion, that is contained from Article 25 to 28. Right cultural and educational right, that is 29 and 30. And right to constitutional remedies, that is Article 32. So if we go back to the Article 14, that is right to equality, here it is equality before law and equal protection of law. Article 15, that is prohibition of discrimination on certain grounds, means not race, caste, and then equality of opportunity in public employment, then abolition of untouchability, then abolition of titles like Raja, Maharaja. Then right to freedom, that is Article 19, freedom of speech and expression, assembly, association, movement, residence and profession, so on. And then Article 20, that is protection in respect of conviction for offences, protection of life and personal liberty, then right to elementary education, then Article 22, protection against arrest and detention, right against exploitation, that is prohibition of traffic in human being and forced labor. Article 14, that is prohibition of employment of children in Factories Act. Then right to freedom of religion, like freedom of conscience and free profession, practice and propagation of religion. Article 26, that is freedom to manage religious affairs. Article 27, that is freedom from taxation and promotion of our religion. Then Article 28, that is freedom from attending religious instruction. Then cultural and educational right, that is Article 29, that is protection of interest in minorities. Then Article 30, that is right of minorities to establishment and administer educational institution. That when contained through Article 32, that is right to move Supreme Court for enforcement of fundamental rights, including writs of habeas corpus, maintenance, prohibition, certiorari and quae warranto. Then what is state? If we consider, there are so many questions. So what is state? There is parliament, state legislature, local authorities and other authorities. So other authorities we have, there are a few cases like University of Madras and Shantabai. Here University of Madras and Madras Universities Act, that is university state, judges said should be agistem generis of the same kind. So university not state, but because it is not the sovereign nature of government nature. So in Ujambai versus state of UP, that is agistem generis, and Rajasthan election board versus Mohanlal, body created by any law for constitution or has a lot of power to effect fundamental rights, so it is not mandatory. Body should be sovereign and government functionary, so by his decision universities are state. So in Sukhdev versus Bhagatram, that is ONGC, LIC and IFSC, that is set up under special statute and performing commercial functions that are state. So in R.D. Reddy versus International Airport Authority, here International Airport Authority, that is formulated under AAA Act 1971, is the state. So court said that even a private body which is instrument or agency of a state, that is a state, if government have usual degree of control on its management and extraordinarily financial assistance. In Som Prakash versus Union of India, we have Bharat Petroleum is under Companies Act. So it is a state in case court have 5 criteria, like whether is a body or state or not, whether financial and resources of state being chief funding source, functional characters being government in nature, and trial control residing in government, prior history of the same activity being carried by the government and made over to new body, some element of authority or command. In Ajay Hansi versus Khalid Mujid, that is determining test whether a body formulated by or under any statute. Determining test is whether is a body acting as an instrumental or agency of state. If yes, then the body becomes state under other authority. So this case gives us 6 determining test criteria, that is entire share capital is held by the government, financial assistance, monopoly status is protective by state, deep and pervasive state control, function of corporation are public importance or related to government, a department of government is transferred to corporation. So what is law and its scope? Then if we consider Article 13, so it's a pre-constitutional laws, that laws not consistent with fundamental right declared void, and all consistent will be valid. So if we consider Article 13 sub-Article 2, that is post-constitutional laws, so that is state prohibits to make such law against fundamental right that if it existent, that laws invalid as per citizens but applicable to company and non-citizens. So if we consider the case State of Gujarat versus Ambika Mills, Labour Welfare Fund challenged. In this, some sections are against fundamental rights. Supreme Court said fundamental rights for citizens, not for company. So Act is valid and these sections still validate for non-citizens. So Article 13 sub-Article 3, that means meaning of laws, any law, regulations, directions, notifications, ordinance, etc. issued by state shall be treated as law. However, administrative direction, instruction for guidance and personal laws are not law under Article 13. That deals with the power of judicial review. So constitutional amendment is not considered as law as per Article 13 sub-Article 4. But in Shankar Prasad case, constitutional amendment can't challenged. After then, Golaknath case, that constitutional amendment can be challenged. Then 24th Constitutional Amendment Act, Parliament added Article 13 sub-Article 4 and it said any amendment that is exercising Article 368 can't be challenged in Article 13. So in Keshwa Bharti case, what happened? The court declared that constitutional amendment can be challenged on the ground of violating fundamental right, which is a basic structure of constitution, but can't be challenged and under Article 13. So Article 13 sub-Article 4, that is Article 368, that doesn't come into the picture. Under Article 38, even violative of fundamental rights. मतलब अगर आर्टिकल 368 का यूज़ नहीं हुआ है, चाहे वो फंडामेंटल राइट्स वो करें, तो भी हम इसको चैलेंज नहीं कर सकते. दिस इज द क्रक्स ऑफ दिस सेक्शन. So if we consider that right to equality, equality before law and equal protection of law. Equality, that means prohibition unequal treatment. Uh, then equality before law, Article 14 sub Article 1. Then there is a demand, there is a equal treatment and equality, uh, equal protection of the law as per Article 14 sub Article 2. So equality before law, that it is an element of the concept of rule of law propounded by the A.V. Dicey, that is a British jurist. So it is a concept of rule of law propounded. Now, British concept have negative approach, like absence of any privilege in favor of any person, equal subjection of all person to the ordinary law, no person is above the law, the law used in generic sense. But rule of law, that is absence of arbitrary power, equality before law, primacy of rights of individuals, so applicable to Indian system. So equal protection of law, that American concepts have positive approach or non-universal approach. Equality of treatment under equal circumstances, similar applicable to same law to the people who are similarly situated, like should be treated alike without discrimination, law used in specific sense. So exception of Article 14, that is President of India and Governor of State during their office, not answerable to any court for exercise of power and duties, no criminal proceedings, arrest or imprisonment during his term of office, no civil proceedings until delivered 2 months notice, foreign sovereign and ambassadors and diplomats, UNO and its agency. Now Article 31C, that is law made for implementing of DPSP under Article 39B and 39C. Now Article 105 and 194, that is MLA and MP are not liable for any of their action inside legislature. Then Article 361A, that is no person shall be liable for true reporting of freedom to publish proceeding of Parliament and state legislature. Then Article 15, that is prohibition of discrimination on certain grounds, that no discrimination against citizens on the ground of religion, race, caste, sex, place of birth, that is no discrimination in giving access to shops, public restaurants, hotels and places of public entertainment applicable to state, and no discrimination in the use of walls, tanks, bathing guards maintained by the state for general public applies to both citizens and state. So state may make special provisions for women and children and advancement of any socially and educationally backward classes of SC and ST. So Central Educational Institution Reservation and Admission Act 2006 passed by the Central, providing quota of 27% for OBC. Supreme Court upheld validity but directed to exclude creamy layer. So if you consider creamy layer, that is children of OBC which not get quota, and person holding constitutional post group A, group B officers, person having rank of colonel and above. Now professional like doctor, lawyer, engineer, so on, person engaged in business and industry, person holding agricultural land above building area above a certain limit, person having gross annual income more than 8 lakhs or possessing wealth above extension limit. So we have important cases like Yusuf versus State of Bombay, Section 497, and women not punished and adultery. This provision comes under Article 15, Subarticle 3. So we have State of Madras versus Champakaram Tarairaju against Madras government order for reservation of every community in medical college. Supreme Court declared invalid and set special provision for advancement of SE, BC, ST and STs by First Constitutional Amendment Act. Here Article 15 sub Article 4, that is M.R. Balaji versus State of Mysore, that is SC strike out his government order said backwardness must be both social and educational, that caste can't be sold, dominant test, 50% selling limit, MPC further categorization not valid, Mysore government order for reservation, that is 28% BC, 22% MBC, then 15% SC, 3% ST. So Indira Sane versus Union of India, here everything turned back override, of which decided in M.R. Balaji case. Here Supreme Court said that only by caste can define backward class, no further categorization of BC and MBC, that is PA in their case here, unaided institution. And we have Article 15, Sub-Article 5, 93rd Amendment Act. Here reservation in private aided and unaided institutions, special provisions for advancement of CBCST and CST, and here 27% quota to OBC. Here state of UP and Pradeep Tandon. Here reservation on the basis of rural areas. Now we have Article 16, that is opportunity, equality of opportunity in public employment. Here no citizen can be discriminated on the or made eligible for employment of any office under the state on ground of religion, race, caste, sex, descent, residence, place of birth. Here Article 15, descent and place of residence are not present. So here exceptions of the Article 16, that is law may be passed for religious institution held by persons of that religion. Constitutional Amendment Act 2003, that right not conferred to OIC. Okay. Here Parliament may by law certain jobs only for the host domiciled in that area, like the Article 371D in Andhra Pradesh. They may be posts that require knowledge for locality and language of that area, and they like very judicial in that case. In some areas, reserves post for OBC, ST, ST, and quota not more than 50%, except in some extraordinary situation. This rule should be applied every year. Then 76 Amendment Act, here placed Tamil Nadu Reservation Act 1994 in 9th schedule to protect it from judicial review, as it provided 69 reservation. Reservation, that means reservation on the basis of residence. Article 16, Sub-Article 3, reserve accelerated development. Here equal opportunity to different areas of a state. Here state can reserved post for backward classes. Article 16, Sub-Article 4, here SC and ST not adequately representation. Here Balaji versus State of Mysore, and Article 16, Sub-Article 4 applies when two conditions: backward classes plus economical not adequate representation in service and on the state. Here Devdasan versus Union of India, carry forward rule case, that is 17% ST and SC. By carry forward it becomes 64% in 1961, but not more than 50% carried forward rule is invalid. So Indira Sane cases and Indira Sane versus Union of India and Mandal cases, here 1979, Commission Chairman of BJP BP Mandal to investigate SEBC in India. 1980, 3,743 caste and 52% of population. SEBC 25% reservation. 1990, that is PM VP Singh implement 27% or backward classes, 27% reservation. SEBC confined to appointment, not in promotion. Reservation not more than 50%, including carry forward jobs, except extraordinary situation, creamy layer to exclude advanced sections among OBCs. RM Nandan Committee, here appointed to identify creamy layer among OBC. Government approved it. 76th Amendment Act 1994, Tamil Nadu 69% reservation in 9th schedule to protect from judicial review. Here 77th Amendment Act 1995, Article 16, Sub-Article 4A, that provides reservation in promotions in favor of SC, ST if they are not adequately represented in the service. Then 81st Amendment Act 2000, that is Article 16, Sub Article 4b, it empowers the state to fill backlog vacancy even if they cross 50% ceiling. So now we have 85th Constitutional Amendment Act that has happened in 2001 that provides consequential seniority for SC/ST with retrospective effect from June 1995. Then Article 16, Sub-Article 5 that reserves in religious institution. Then 103 Constitutional Amendment Act 2019 that amends Article 15 and Article 16 that provides for reservation 10% in government jobs and educational institution for economically weaker section in unreserved category. Here, abolition of untouchability, that is, abolishes untouchability. It is applicable to state and private citizens. Untouchability is not defined in Constitution or Civil Rights Protection Act. Untouchability Act 1955 renamed to Protection of Civil Rights Act 1976, that is punishment either by imprisonment up to 6 months or fine up to 500 or both. Persons convicted untouchability is disqualified for election to parliament or state legislature. So SC/ST, that is Prevention to Atrocity Act 1989. Here we have J. Singh versus Union of India. There are so many cases, we are not discussing it. Now we have abolition of titles, that is, state cannot confer any title or on a citizen or foreigner, prohibit state from conferring any title to anybody except military and academics. That citizen can't accept any title from foreign state. A foreigner working for Indian government can't accept a title from foreign state without the consent of the president. So no citizen or foreigner holding any office of profit shall not accept any present emolument without the consent of the president's. Bharat Ratna, Padma Award are not titles, not to be used as suffix or prefix to the names of the awardees and don't come within the constitutional prohibition. These national awards instituted in 1954 but discontinued by Morarji Desai, that time government Bharatiya Janata Party, in 1977, but again revived by the Indira Gandhi government. Now we have protection of 6 rights in Article 19, that is freedom of speech and expression, freedom of assembly, freedom of association, freedom of residence, freedom of movement, freedom of profession. So let's discuss each one by one. So Article 191A. Here, freedom of speech and expression, that is, every citizen has a right to express his belief and conviction. It includes freedom of press, freedom of information, silence, freedom against banned, right to telecast, advertise, so on, right to know about government activities, right to demonstration or picketing but not strike. Under it, recently decriminalization of homosexuality under Navdeep Singh Johar versus Union of India, restriction on ground of sovereignty and integrity of India, security of state, frontier relations with foreign state, public order, decency or morality, contempt of court, defamation, incitement to an offence. Now we have cases like Bejoy Enumement versus State of Kerala. Here, national anthem, that is Jehovah Belief, National Honor Act, freedom of speech and expression also include right to remain silent. Brij Bhushan versus State of Delhi, Sakal Papers versus Union of India, that is freedom of press. Now we have A.K. Gopalan case versus State of Madras, Chintaman Rao versus State of MP, Ishwar Prasad versus N.R. Sen, Hanif Qureshi versus State of Bengal, give many guidelines restrictions are reasonable or not. Article 19, Sub-Article 1, Clause B, that is freedom of assembly. Every citizen has a right to assemble peacefully without any arms. Actually, they can conduct meetings demonstrations, and take out procession. These right does not include right to strike, restriction on grounds of sovereignty and integrity of India. Public Order Section 144 of CRPC allows magistrate to restrain an assembly or meeting or procession. Under Article 141 IPC, assembly of 5 or more persons can be made unlawful. Then Article 19, Sub-Article 1, Clause C, that all citizens have right to form association or unions or cooperative societies, right to form political parties, etc. Right to obtain recognition of association is not a fundamental right. Supreme Court, that is, trade unions have no guarantee right to effective bargaining or right to strike or right to declare a lockout, restriction on grounds of sovereignty and integrity of India, public order and morality. All India Bank Employee Association versus National Industry Tribunal, right to strike or lockout, not covered in Article 19 Sub-Article 1 Clause C. Article 19 Sub-Article 1 Clause D, that is, citizen can move freely throughout the territory of India, any country, ठीक है, on the country, in India basically. Restriction on grounds of interest of general public, that is protection of interest of tribals, that is Supreme Court freedom of movement of prostitutes can be restrict for health and public morals. Now Bombay High Court's validate restriction on movement of persons affected by AIDS. Article 19 protects only internal movement while external movements dealt by Article 21. So Article 19 Clause 1 Subclause E, that is Article 119 Subarticle 1 Clause E, that means freedom of residence. Every citizen has right to reside, settle any part of the territory of this country. Now, restriction on grounds of general public interest, protection of interest of scheduled tribes on prostitutes and habitual offenders. Now, Article 19, Sub-Article 1, Clause G, that is, citizen has a right to practice any professions, occupations, trade or business. Restriction on grounds of public interest, professional and technical qualification, license, etc. are necessary. However, state can monopolize a business. Now, Article 20, that is protection in respect of conviction for offences like no ex post facto law. Article 20 Sub-Article 1, no person shall be convicted by applying law backward, and no penalty greater than prescribed applies only to criminal laws, not to civil and tax laws. Do not apply to prevention detention cases related to Kedarnath versus State of V.B. Ratan Lal versus State of Punjab. No double chibadi. Article 20 Sub-Article 2, that is, no person shall be prosecuted and punished for the same offence for more than once. Available only for proceeding before court of law or judicial tribunal, not before departmental and administrative authorities. Now we have a Thomas Das versus State of Punjab. Here, condition for protection under Article 20 Sub-Article 2, you accused for an offence. Prosecution would be continued for the offence and result for this prosecution should be punishment. Now, Makbul Hussain versus State of Bombay, that is Sea Custom Authority, that is Foreign FEMA, here Foreign Exchange Regulation Act, FERA. Here, Supreme Court said Article 20 Sub-Article 2, protection only when prosecution by judicial authority, so you can't take then Article 20 Sub-Article 2, that is protection under departmental, administrative, quasi-judicial body. Here no self-incrimination. Article 20 Sub-Article 3, that no person shall be witnessed on uniform case, blood sample, specimen signature, thermal exhibition of body, production of material objects are not covered here. Then applicable only to criminal cases like both oral and documentary, and not in case of civil proceedings. Cases related to Nandini Satyapati versus P.L. Dani, that is State of Bombay versus Kati Kulu case. Here Article 21, that is protection of life and personal liberty. Here no person shall be deprived of his life and personal liberty except according to procedure established by law. This right is applicable to both citizens and non-citizens. The Supreme Court in Maneka Gandhi case following that right as a part of Article 21 here, decent environment, shelter, health, free education up to 40 years of age, free legal aid, against solitary confinement, speedy trial, against handcuffing, against human treatment, against delay execution to travel abroad, against bonded labor, against custodial harassment, to emergency medical aid, timely medical treatment in government hospital, not to be driven out of state, fair trial, prisoner to have necessity of life, women to be treated with decency and dignity, against public hanging, hearing, information, reputation, and appeal from a judgment of conviction, social security and protection of families, social and economic justice and empowerment, against bar, fetters, appropriate life insurance policy, sleep, freedom and noise pollution, electricity, livelihood, life with human dignity, protection against hazardous industry, privacy. Now, right to education, Article 21(1)(a), that the state shall provide free and compulsory education to all citizens of age 6 to 14 years. Here added by Article 86 Constitutional Amendment Act of 2002, before it Constitution contained in Article 45 in Part 4 in 1993 itself. Supreme Court recognized a fundamental right to primary education in right to life under Article 21. Here Parliament also enacted right to life, right of children to free and compulsory education in 2009. Now we have a due process of law and process established by law. Due process of law, that means due process balance the power of law of the land and protects the individual person from it. Now procedure established by law, that is power of law of the land and protects the individual from it. That is a law that is duly enacted by legislature or its concerned body is valid if it has followed the correct procedure. Now we have A.K. Gopalan case and Maneka Gandhi case. In both cases, what happened? Arbitrary education actions that is available in both the cases. Then arbitrary legislative action that is not available in A.K. Gopalan but is available in Maneka Gandhi case. That is unreasonable, unjust, unfair laws can be questioned by judiciary. That is due process of law is not available in case of A.K. Gopalan but is available in Maneka Gandhi case. Meaning of liberty, that it means only to liberty relating to person, body of the individual, and in Maneka Gandhi it is more wider and positive interpretation of liberty, opportunity to live with a dignity and to develop to one's capacity. Now we have right to die, that is P. Ratinam vs. Union of India. Under our section 309, Supreme Court said this section would be invalid. In Kinkar Court vs. State of Punjab, waiver of fundamental rights not allowed in Indian Constitution, so action section 309 is valid. So right to privacy, we can say Karnak Sikh vs. State of UP. Here life mere is not mere animal existence. If unauthorized disturbance would be violation of privacy. Now we have PUCL versus Union of India, that is telephoning tapping case. Here till public emergency safety versus right to life. Now we have a right to environment, that is REL versus State of UP, that is unauthorized mining, letter, Supreme Court reputation. Now MC Mehta case, now T Damodar case. Now finally, right to live in healthy environment is a part of Article 21. Article 21 and emergency, that is Article 359. President has power to suspend Article 21 and 1962, 1971, 1976. ADM Jabalpur versus Shivkant Shukla and Article 21. 44th Amendment Act, Article 359 amended. Article 21 can't be suspended. Here, Article 22, protection against arrest and detention, that grounds to be informed, right to consult and defended by a lawyer, right to be produced by a magistrate within 24 hours excluding journey and holidays, and it shall not be detained for more than period that authorized by a magistrate. Then now we have punitive detention. that is punish a person for offense committed by him. Now we have preventive detention, that is detention of person without trial and conviction in court, and it can be detained with for 3 months beyond that advisory board shall permit. Now the board shall consist of judges of High Court. Parliament by law increase the period for preventive detention for more than 3 months without obtaining opinion of advisory board. Legislative power with regard to preventive detention, that is division between Parliament and state legislature. Preventive detention law-making powers, that means center and state. 7th Schedule List 1, 7th Schedule List 2, that is for defense, foreign affairs, security of India. Now in State List 2, that is maintenance of public order, security of state, maintenance of essential services. Now we have Article 23, that is prohibition of traffic in human being and forced labor available against state and private citizens. State can impose compulsory service for public purpose without any discrimination on grounds only of religion, race, caste, sex, class. Now we have Article 24, that is prohibition of employment of children in factories, that does not prohibit child labor in non-hazardous industry, child labor prohibition and regulation. Article 2016 prohibits all kind of employment of children below 14 to 18 years, children in hazardous industry. Now we have Article 25, that is freedom of conscience and free profession, practice and propagation of religion. Now we have do not provide right to religious conversion, that covers religious belief and practices. Hindus under Article 25 includes Hindus, Sikhs, Jain, Buddhist, that is reasonable restriction, public order, morality, health. State can regulate economic, political activity that is associated with religion and can provide welfare reform of the religious institution. Now we have freedom to manage religious affairs, that is religious denominations that can establish, maintain, manage and acquire property for religious and charitable purposes, that necessary conditions by Supreme Court to be considered as religious denomination, system of belief, common organization, distinctive name. Now Article 27, that is freedom from taxation for promotion of our religion. The tax cannot be levied, but fees against the service can be levied, and this article prohibits only levy of tax and not a free. Now Article 29, that is freedom from attending religious instruction, that is no religious instruction and educational institution wholly maintained out of state fund. Now distinguish between 4 type of educational institutions. Now educational institution, that is institutions wholly maintained by state and institutions administered by state but established under any endowment or trust, that is institutions recognized by the state, institution receiving aid from the state. Now religious instruction completely prohibited, religious instruction permitted on voluntary basis, students may or may not attend, permitted on voluntary basis, student may or may not attend. Now Article 29, that is protection of interest of minorities, that is to conserve script, language and culture, that it is available for both religious and linguistic minorities, that is no citizen can deny admission to any educational institution maintained by the state or receiving aid from the state only on ground of religion, race, caste or language. So it includes both majority as well as minority by the Supreme Court. The political speeches on promises made for conservation of language of a section of citizens does not amount to corrupt practices under Representation of People's Act 1951, Here, right to minorities to establish and administer educational institutions, that is, institutions enjoy right to property. Here, resolution for OBC's 93rd Amendment Act that do not apply to these institutions. Here, applicable only to minority institution. Here, also include to impart education to its children in its own language. Here, right to move Supreme Court for enforcement of fundamental rights, that including the writs of habeas corpus, that means to have a both body against both, whether it's a public body, whether it's a private body. Here, Rudullah Shah versus State of Bihar. Here, mandaments means command to perform a public duty. Here, any public body, corporation, inferior court, tribunal, or government. Okay. Now we have Gujarat State Financial Corporation versus Lotus Hotel. Here, not against persons of India, Governor and Chief Justice of High Court, private body or individual. Prohibition, that means to forbid, against judicial and quasi-judicial authorities. Certiorari, that means to be certified, that is Supreme Court and High Courts, lower courts. Here, Gullapalli Nageshwar Rao versus APRSRTC, AK Kripak versus Union of India. Equivalent of that means by what authority public officer can't issue against ministers or private office, unlike other four writs. Any person can file basic feature of constitution. Parliament can empower any subordinate court to issue writs of all kinds. President can suspend the right to move to any court for enforcement of fundamental rights during national emergency. Borrowed from English law, Supreme Court and High Court can issue a remedy against under Article 32 itself is a fundamental right. So Supreme Court may not refuse to exercise its writ jurisdiction, but a remedy under Article 226 is a discretionary and has High Court can refuse it to exercise its jurisdiction. Now, fundamental rights, that is applicable to any person, whether citizen, article any person. It's 14 and Article 17. Citizens only are 15, 16, 19, 29 and 30. Article and for citizens and foreigners we have Article 18, 21, 22, 23, 24, 25, 26, 27, 28, and citizen, foreigner and legal person we have Article 20. And if we conclude fundamental rights applicable against state only, then we have state plus private plus individual. Now some important related to fundamental rights. Article 33 that empowers Parliament to restrict or abrogate the fundamental rights of the members of armed force and then parliamentary forces, police forces, etc. Article 34 that provides restriction on fundamental rights, while martial law reinforced in any area. When originally right to property was one of 7 fundamental rights, but 44th Constitutional Amendment Act 1978 abolishes it and inserted it in Article 300. Article 300 Article 300 sub-article 1 in part 12. Now right to privacy, that means on article 24th August 2017, Supreme Court held that it is integral part of right to life guaranteed in article 21 of the Constitution. Every fundamental right is a human right, but not the reverse. Right to vote is not a fundamental right. It is a right given by section 62 of Representation of People's Act 1951. Every fundamental right is a constitutional right, but not reverse. And now we have right outside part 3, that is known as constitutional right or legal right or non-fundamental right. Now we have right article 265 part 12, that is no tax shall be left or collected except by the authority of law. Now we have article 300, that is part 12, that no person shall be deprived of his property. Then article 301, that is part 12, that no person shall be deprived of his property. Article 301, that is trade, commerce and intercourse throughout the country of India shall be free. And article 326, that is article part 50, that is election of Lok Sabha and state legislative assembly should be on the basis of adult franchises. And now we have case violation, that is constitutional remedies. And now we can have another, like we can move to the High Court by ordinary suit or under article 226 writ jurisdiction of the High Court.